Welcome to the LightUp noon seminar. We just kicked off the seminar an hour earlier, where we shared great food in the room, and we still can smell the delicious food. Oh, by the way, you guys can eat. There's food right there. My name is Echo. I came to US for PhD in engineering, and after that, I worked for Intel for 16 years. And eventually, I just don't feel I could get control of my time, and also I pay way too much taxes. Being a W2, because my husband still works for Intel. I want to be a entrepreneur. I became licensed in 20, then became full-time in 2018. And I really enjoy getting to know families, and just based on my personal experience, it's really hard to work so hard but have no time or knowledge for your personal finance. And I have my twins who are going to college this year. I can tell you all about college planning. But I'm a busy mom, but I also enjoy self-improvement. I'm a Toastmaster club. I will be I'm a great Toastmaster. I'm also a board director at a local school. And the company or platform, LightUp, is very unique in the way that we combine specialists from different areas. Today we have Tom as our guest, the specialist, but we focus on tax planning and strategies, wealth management. We also focus on family protection. And what is unique is we bring all the experts in different areas into one place for easy access to our clients. So we are a power team. And we are very heavy in CPA presence in the team. And then we are also very heavy in holistic approach for financial planning. Aris and I are in local Oregon, but as you may see, we have different people in different areas. Tom, your camera is off. I'm about to introduce you. Today, I want to do something different. So I have known Tom for many years. Tom, I've known you for about 10 years. It has been this long. And I always tell people that there are many estate lawyers, but there are nobody like Tom. Tom has been doing this for 30 years, and he was an orphan to begin with, and he had this love to help out families. And he's also a tax lawyer. You don't see this combination very often, but you will see this strength. It's so beneficial to clients because when you plan for estate planning, it's not just the estate planning, it's your overall family planning. And I have seen estate plans that my clients already have. I'll look at it and feel that, hey, you should really sit down with Tom because he will give you more and deeper and more about perspective. So I respect Tom a lot. And you can, if you heard our earlier chat, we're talking about families and the kids because we have known each other that long. I don't have any personal gain from Tom's business. Neither Tom has from my business, but we just respect each other and work very well together. I have heard several questions in the local WeChat group about estate planning. I said, hey, let me organize something for Tom. So here you are. Today we're going to do something different rather than Tom going through slides and he talked pretty fast. I would like to have a free forum where I have a list of questions. And if you have questions that I have not covered, you're welcome to put in a message in the Zoom. I will come to that. But let me start, just kick off and ask Tom some questions to get him going. Why can't we just write a note as last will? I can write on a napkin, Tom. Isn't it sufficient? I think that's people's common perception of estate planning. I just need to leave some words. Does it work?
So you know what? There's Supreme Court justices of the United States Supreme Court that did that. Some actually think that's true. They can just scribble a name on a note, some information on a note and put it in their drawer. That's not possible. That's impossible. The idea is like if you have young children and you have somebody watching your kids, like a nanny, a pair, somebody like that, and you just scribble your phone number on a napkin and say, we'll be back in 4 days, power to do anything. If she's in a car accident or your child gets hurt or there's a healthcare emergency, nobody has any power to do anything. Now, there is something in most states, and we're really focusing on the Pacific Northwest, but most of these things are universally true in all 50 states and all of US territories. You can do what's called a holographic will. That's a handwritten last will and testament. Typically, you can't do holographic other documents, but there's a very high failure rate, not only with wills that are downloaded off the internet on Wills and Trusts, LegalZoom, do it yourself. You can buy these do it yourself kits at Costco and places like that. There's like an 85% failure rate with those documents. So I'm not telling you it's totally impossible to do what's called a holographic will. That's a handwritten will. But there's just a simple will has 23 different legal requirements. The will is the most complex estate planning document. A lot of people think it's the most, and it's not. So my advice, never handwrite your real estate contract, your instructions for your children so they're not orphaned, your estate plan. Those are not documents that should be handwritten. And I don't know about you, but my children can barely even write anymore. They've been using computers for so long. I usually can't read my clients' handwriting, their signatures. I had my fourth grade teacher made me learn how to write very clean. So I know how to write my name and stuff, but a lot of people don't even use the number 2 pencil anymore. So my bottom line is don't handwrite your estate plan documents.
I hear you, Tom. I was telling my son who is dating this lovely girl, I said, luckily you don't need to write love letters. She won't be able to read it because I can't read his handwriting.
Now, if it was a love letter, I'm not the person to give the advice. Maybe that would be, I think there is some power in writing a note, an I love you note to like somebody you love.
That's true.
That should probably not be, texted, used by text or hand. So my parents told me that writing a thank you letter to people for a gift is a good gesture. So that's a separate issue.
Yeah. Tom, some of my friends always say, oh, I have a will already. It's a living trust. I'm not rich.
So that's the most common. Statistically, about 7% of people in the United States have a estate plan. Now, what is an estate plan? That's about if you went to buy a car at the dealership, an estate plan would be the whole car, the tires, the wheels, the transmission, the engine, the power steering, the brakes, right? A will is like getting one tire or a steering wheel. Would you buy a car and only leave the dealership with a tire? I mean, you can't drive the tire, but the will is like the steering wheel. It's one small component of an estate plan. It's like buying a house, but the house doesn't have a roof on it. It doesn't have electric. It doesn't have plumbing. From the street, it might look like a house, but you can't live in it. There's no utility, right? So that's the most common thing people say is like a financial, like Johan will refer a client to me and say, oh, they're good. They already have their will done. What happens if you just have a will? Now, most people need a will and a trust, and I'll talk in more detail in a few minutes, but the main reason you need to have children who are under the age of 21 or 18 or 19, depending on the state, but they can't live, I have 3 kids who are still college age, and they don't have a house. There's no way they could pay for their own college, their own health insurance, food, transportation. I mean, they work a little bit and earn a little bit of money, but if their mother and I both died right now, or we were both disabled and we could not take care of them, we would need to name guardians for them in our will or our durable power disabled or we died, so that they would have a place to go. They would not be orphaned. Your child can be 23 and still in college and have no money, and they still need a house to live in and somebody to take care of them. So typically you need a will or a durable power of attorney to name backup parents for your children until they're probably about 25 years or older. Not when they're 19, because I don't know a lot of 19-year-olds that could just, if their parents died, they could just live on their own. So a will is a vital document. It's a super important document. And most of my clients have a will and a trust, and that's the main purpose of a will. If you don't have a trust, also, the will, you have to remember, doesn't go into effect until you die. Probate, it basically locks you out of your own house, and nobody can do anything until you die. A will is not a living person's estate plan.
You remember, Tom, why I called you out of emergency end of last year when my friend all of a sudden lost her husband?
Yes.
Was out Christmas shopping and he just collapsed. There's no warning.
How many, in the 10, 11 years I've been working with you, we've had that happen.
Too many.
The girl, the 10-year-old girl, her parents were swimming on the Oregon coast and they drowned.
Yeah, the wave just come and grab them, right?
I mean, we've had like 7 or 8 people we know in our circle of our own family, our own friends, our professional life. Half of die or become disabled every year in the United States have minor children. And then like 90% of the assets in the United States are owned by men. Cultures them into own assets in the Middle East. And we have a lot of refugees who moved here and they don't have assets in their name. But women are vulnerable because they live usually 10 or 15 years longer than men do. And children are really vulnerable because nobody can protect them except children can't do any planning for themselves. So it's really important for single moms, single dads, widows, widowers, and married need to get on top of this and collaborate. Otherwise, possible time when you least expect it. Like I said, about half of the people that die or become disabled every year in the US are under the age of 50. So the client that says, I'll do this when I'm 87, I'll wait till I'm old and then I'll do my estate plan. That's not a good strategy.
Talking about the people in our common circle, there was one client who you were helping, but he did not finish the trust with you. I think he was interested in the business continuation plan because he was in his 40s and brilliant. And he called me in China in the middle of COVID saying, I made too much money this year. I need Tom to help me reduce my taxes. And the next thing I know, he was in the hospital getting the IV done. I said, what happened to you? He said, oh, I'll probably eat some bad seafood. And then he got pancreatic cancer. He had surgery in Shanghai, and then he came to LA for chemo, and it took less than the age of 46. And and his wife called me and said, where I can get immune record for my children, because he handled everything. She doesn't even know who is their pediatrician. So it's very real. It happens around us and continue to happen until people become more aware. So I'm a big advocate about people know what they're dealing with, what happens, right? How to
Absolutely. Get yourself ready. And then my wish for all my clients and for my mom and dad and myself and you, that we're all going to live till we're like 108 years old, never get sick, and die of natural causes in our sleep with great grandkids who are in perfect health. That's our dream. But if you just watch the news or paper, that's not the way the world is.
No, it's not, even for people around us. So the trust will avoid probate, and then if we leave the heartbreaking part of taking care of children aside for a little bit, what does it do to transfer assets? How I can make sure that the money goes to the kids in the way that I intend to be? Because I have two 18-year-olds going to college, and God forbid, if something happened to me and my husband, I don't want them just to have this lump sum of money, all of them become available, right? That's
correct.
Implementation. So tell us what can
the first part of the question is probate. So what happens, and by the way, there's in Washington, we call community property law that can impact what happens. Here, most clients they're married, they have a community property agreement, which is like a super will and can accomplish some objectives and some tax planning objectives. Oregon is a common law state that still uses 600-year-old English law, 14th century. And there is no community property escape valve. But right now, the state legislature, there's a bill, Senate Bill 15, going through the Oregon legislature. They're looking at increasing how much of the estate is exempt. Like right now, it's only $7. So once you're over 75,000, you have to go through probate. That's just about everybody. The limit on a house is $290,000. Who has a house that's worth less than $290,000? I mean, to raise those numbers, but the people that fight it are probate lawyers, because probate is a $50 billion a year industry. It's very lucrative to do the work. When somebody you love 6 million people a year, or somebody you love has a stroke or a car crash, you're either going to go through living probate. That's the person who can't make their own decisions. So you have to set up a guardianship or conservatorship over them, financial and healthcare. Or when they die, how do we get their name off all the assets? That's called probate. If you have a estate plan, it will govern what happens to the assets. But like I said, there's a very high failure rate of people that download and self-prepare their own documents. Probate takes about 18 months in Oregon and Washington. In Oregon, the person who handles the probate gets 1 to 7% of your estate, and the lawyer gets a reasonable fee. In Washington, it's all fee, but it's usually 3 to 5% of your assets in about a year and a half. You're completely locked out of your own house. You're on the street. All you have is the clothes that you're wearing, basically. It's like a natural disaster happened. And you don't have control. You have to hire lawyers charged between $600 and $800 an hour now in the Pacific Northwest. And it's cheaper here than it is in places like San Diego, New York. Can you imagine paying a lawyer for $500 an hour? It's completely unnecessary. It's voluntary to go through. So don't do it. Now, if you have less than that, no children, you just need a will plan. But just about has more than that in assets and has children, they want to structure things. Now, second part of your question, you or I pass away, we have college-age kids who are great kids. They're very mature. Gen Z, as they say, is frugal, hardworking, ethical, good people. If you have some life insurance or a house or without leaving millions of dollars to your child, they're still in their formative years. They could be 28 years old and still barely out of college. Is it avoids probate while you're living and when you die, because we prepare an estate plan to keep you out of the probate system and to make sure that you can stay in your home, live well, have people around that love you, remain engaged in the world, and have a good life. And then when you die, empower people to take care of everything that needs to be taken care of. But what I recommend is structuring the inheritance for your children. So what they need to finish college, and so they aren't like on the street and homeless and all that. Take care of their life necessities. Give them a little bit of spending money, help them have success, but hold everything back until they're probably about 30 years old. And then if it's fairly distributed over about a 10-year period. So the trust becomes a irrevocable separate trust after you die. And if your child gets divorced or they get married or they get in a car accident or they're financially immature, everything's blown up in 1 year. You can structure it however I recommend it. Incentivize financially responsible behavior and pay for things that you think are important. And don't incentivize people financially immature, blowing all the. We have a duty to educate our children before they're not going to learn things in high school and college. So as parents, we should educate our children. I know that that's what life's one of its great features is teaching families about money because the high school and college won't do that. But as parents, we should also be doing that.
Absolutely. Revocable trust. Can you elaborate on the key differences between the two?
All right. So while you're living, the trust is your last will and testament. Basically, its purpose is to determine who gets all your assets out. It's that simple. It also will make sure that you have two, Oregon and Washington, depending on the state you live in. You'll have your full married. Typically, what happens if you're married is everything goes to the surviving spouse. There's no plan to protect the assets if the surviving spouse remarries. And when the surviving spouse dies, there's only one estate tax exemption. Typically, there's also a probate. These are all bad outcomes. The trust keeps property, make sure that your wishes have to be fulfilled after your death, even if it's 30 years after your death, that there's no probate, that there's no guardianship or conservatorship, that your children are not orphaned. And if it survives, they control their share of the estate, but they can't disregard the deceased spouse's share of the estate. And then once you're both gone, while you're living, it means you can amend your plan however you want to, because life's going to change, right? The other thing about a trust is you can go live anywhere in the world if you have a trust. It's portable. As with all estate plans, if you want to have benefits of the state and federal law in the United States, you have to have a U.S. person be the trustee of your trust after you die. So I'm a U.S. person. I'm a U.S. citizen. When I die, non-U.S. citizen is my trustee. Otherwise, I lose all the tax protections I have in the United States. My trust is a foreign trust. So there's a lot of special rules around citizenship, and about 95% of my clients are tech workers who came here and are not U.S. citizens, but they have H visas, green cards, they're U.S. residents. And there's some additional planning that has to be done because of their citizenship status, but I can help them opt in to all of the tax protections we have. But once you're gone and your spouse is gone, the trust becomes irrevocable. And all that means is that your final wish is executed. You can die on your deathbed and know the plan that I devised is going to be carried out as I directed. If your children aren't happy with it and they decide to hire a lawyer and start litigation, now if there was a probate, that actually has to happen. That's like an evite for litigation if you have a will plan. The living trust, if just the child decides to do that, they'll just be disinherited, like they're already dead. So your child has to respect your wishes and be grateful for what you've done for them. We all love our children, so we're not going to punish our kids. We're going to be very generous with them. But I have 3 kids. So let's say that I pay for my son, I buy him a nice house, I pay for his wedding, his education, and I give him $2 million on his 40th birthday because he wants to start something. On my death, I might say, I'm giving all the rest of my estate and nothing to my son other than my love and affection because I gave my son $3 million on his 40th birthday. It's important because 40 years later, my son might think I don't love him. Well, he needed the money while I was living. I gave my daughters almost nothing during that time. So I might give them more when I die. But what if my son decided to, the kids were unhappy, decided to hire lawyers and start a lawsuit? They would all get nothing if that was what they decided to do. They have to respect what I did for them. And I have reasons for that. It's not that I don't love them. I just want to be fair and equitable. But the bottom line is an irrevocable trust creates protection for your children and grandchildren and also keeps their inheritance as separate property. Are cohabitators. Or either that or they're going to have a very failure rate in marriage, sadly. 60% of all marriages in the United States fail. So a lot of the Zoomers and millennials are 9 out of 10. They're just going to live together. There's no rules for that. So having a trust will become increasingly important in the future.
I always tell people that because community, we are first generation immigrants. And some of us, one of the couple has a US status, half may just keep the original status. So the tax in US is very complicated. And they
Very. Yeah, national.
Yeah.
You only have a $60,000 estate tax exemption in the United States.
60.
$60,000. That's it.
That's like nothing.
But opportunities that you have as a foreign national that U.S. citizens don't have. For example, you can buy insurance and there's no estate tax on national, but if I have a life insurance policy and I own it when I die, it's subject to estate tax. I can give you a bunch of examples. One of the real dangerous things is, like, I'm divorced and I'm a U.S. citizen. If I decide to remarry and I marry a woman who's not a U.S. citizen, I can't just put her on, the natural thing would be I'll put you on the title to my house and all my bank accounts. We'll just join all our assets and own them as husband and wife. But I'm actually limited. I can only put $190,000 of assets per year in her name. So let's say I put her on the title to my home in Seattle. My home's worth about $1.5 million. I can only give her 190,000. So if I put her on the title, that's 750,000, half the value. That's a taxable gift. It's like, but she's my spouse. Well, I can't do that. Yeah. I can give 19,000 a year to else, and I can give $190,000 a year to my spouse if she's not a U.S. citizen. And this is true if she's, so we love our spouses. So the natural thing is let's just combine all our assets. But there's rules that you need to be aware of that are like, but there's also opportunities. The issue is, you die, just make sure that there's a U.S. trustee to manage your financial affairs and that you have a trust. And if you have a spouse, probate, and we can defer and postpone estate taxes until the second spouse dies. And if the second spouse does decide to become a U.S. citizen, that will create additional planning opportunities. So we were talking about the scenario earlier where a 48-year-old spouse died of cancer or had a car accident. That happens, like, I get 25 phone calls a year with that scenario, right? It's almost always men. And then the widow calls me and she's 2 teenage kids. All the assets are in the husband's name. There's no life insurance. And the surviving spouse is not a U.S. citizen and there's no estate plan. That's the phone call that I get. It is catastrophic for that widow in that situation. It's like, how could you leave this situation in such peril? And it takes us an avalanche. Digging out of it is very difficult. You can spend 5 or 10 hours and build an estate plan, avoid all that.
When you mentioned when your spouse is not U.S. citizen, if she are, the same limitation still exists, right? It has to be a citizen in order for her to be put on title for half of.
I mean, the default question is, yes, that's true. We do have treaties with Canada, Mexico, and about 14 other countries where you can be a dual citizen or you're a citizen of that country, but they have treaties with the United States. So we're not going to get technical in this, but I am an expert on international tax and estate planning. And there aren't a lot of lawyers that have that training over 35 years. Really important to make sure that you're not dealing with somebody who's an amateur or very new to these issues because they are super complicated. But the safe harbor is to create a trust, name a U.S. person to be a successor trustee, name your sister, your CPA, a trust company. Sometimes it's hard to find that person, but don't name a foreigner as the trustee of your trust. That's always a bad option. Now, if you're disabled, you're still alive, you can have a foreign person be your healthcare agent, financial agent, trustee, because you're still alive. But after you pass away, after I pass away, I have same rules apply to me as a U.S. citizen. Person or a U.S. trust company is my trustee. Law firm. The trust and estates group at my law firm has about 10 people and always has since like 1960. So I have that luxury. I can just name the trust and estates group at my law firm. Not everybody has that luxury, but I'll help you plan. I'll help you come up with some ideas and options.
Tom, during the COVID, so many Oregonians moved to Washington for the tax benefits. Can you explain to us the difference between in Oregon and Washington for estate?
So I made that decision in 1996 after practicing for almost 10 years in Oregon. I went to law school in Oregon. I lived in Lake Oswego in Northwest Portland, and I loved Oregon. And I spent about 100 work days a year in Portland and just loved my whole family. I'm going to retire in Oregon. You got to live where you love. But if you move 5 miles to Camas or Vancouver, your income will be higher statistically than it is in Portland. So now you're 30% ahead. You can still go over to Oregon to buy stuff to avoid the sales tax. And Washington doesn't sales tax healthcare or food or necessity. And starting July 1st, we're going to have a $3 million estate tax exemption in Washington. The exemption in Oregon is only $1 million. So by moving 5 miles, you keep % more of your income. And a husband and wife have a $6 million estate tax exemption. In Oregon, that's only $2 million combined or $1 million each. So I'm not going to tell people. I mean, I lived in Oregon my whole life until once I moved up here, I thought I can have my cake and eat it too. I can spend as much time as I want in Oregon. I can buy Christmas presents there and TVs and things like that and keep more money. And when I die, my family can inherit more money. So those are some of the legal reasons. Also, if you're a Washington resident, when you die, all of your capital gain is wiped out. So the spouse gets a step up in basis, all of the brokerage accounts, real estate. You could have depreciated your investment real estate. You could have NVIDIA stock, whatever. The surviving spouse gets a new tax basis because she's living in Vancouver, and she can sell everything completely tax-free. We do have a capital gains tax in Washington now, but it's much lower than the Oregon capital gains tax, and it's only on stock sales. Okay. In Oregon, both spouses have to die, and then your children get that new tax basis and tax windfall. So the priority is given to next generation children and grandchildren in Oregon. In Washington, the priority is given to the surviving spouse. So again, my parents have a ranch in Central Oregon. I grew up down near Corvallis. I went to college in Eugene. I love Oregon. I'm going to retire in Bend. So you can't just live in a place because the taxes are high or low. So I know there's a lot of consideration. We should analyze this. And 50 clients moved from places like Bethany and Lake Oswego over to Camas. Camas has 5 Street of Dreams neighborhoods. It looks out over Mount Shasta, Mount Hood, and from Gresham or whatever. So I'm not telling people to go live on the other, but it's not like your world's going to come to an end if it would cost your children $5 or $7 million when you died. It's a consideration. You should be aware of that. You can also go live in places like Lake Tahoe, Nevada, Sun Valley, Idaho, Scottsdale, La Quinta. None of those places have estate taxes at the state level. A few of them don't have income taxes either, like Lake Tahoe, Nevada. So we look at these strategies in years. If you were going to have a second home, maybe make that your primary home and live in Oregon 170 days a year and don't be an Oregon resident between May and October and home, but don't be an Oregon resident when you're in your retirement years. So if you already have, if you're thinking about getting a vacation home, we should strategize and think about where would be a good place to have that home. Live there 190 days a year.
Yeah, I'm actually seriously thinking about that. Now the kids start going to college. I don't have to be living in Oregon anymore, I can get a second home.
Likes to be on the uprise again, coming out of COVID. I'm bullish about Portland. We keep having surges of revival over the years. Seattle, the same thing happening right now. Salt Lake City, all these West Coast cities. San Francisco is resurging and things are getting better. You have to think about the consequences on your death if there's a punitive tax system, or California, the Buffett tax. I mean, they're taking 18% of your income every year for the rest of your life.
Crazy.
That can be very punitive.
We got a watch audience asking to get a full step up in basis when one spouse passes away. Does it mean you will have a second full step up when the second spouse passes away? Can you explain that?
So the answer is yes, unless you want to make sure that remarriage provisions in your estate plan. So 7 out of 10 surviving spouses are going to remarry. Okay. Let's say 2 people are married, cancer when they're 60, and the widow lives another 30 years, and when she's 70, she remarries. You got to be careful to make sure that that person who you remarry doesn't steal the estate from your kids. When the first spouse dies, the way we protect their exemptions and honor their wishes is to put their share of the assets into these bypass trusts with the surviving spouse beneficiary, and then we put remarriage protection provisions in. Assets that you put into a Washington or Oregon credit shelter trust to capture your estate tax exemption, those avoid estate taxes forever. So if I die in a shelter trust to capture my $3 million Washington estate, and then my spouse lives another 30 years, those assets in my Washington credit shelter trust basis because they're avoiding Washington estate tax. Now, if those assets grow from 3 million to 8 million during my surviving spouse's lifetime, they avoid estate tax. But if somebody sells them, that gain between 3 and 8 million is subject to capital gains. So I don't want to get technical, but you need to work with a tax lawyer who understands all this. I have clients that died 30 years ago that put, when the exemption was only $600,000, and they put Microsoft stock in their credit shelter trust. And some of those trusts now have $30 million in them. And when the surviving spouse dies, there'll be not in the surviving spouse's estate. The children inherit $1 million estate tax free. But remember, it only had a $600,000 basis in 1997. So we have to be really careful about what happened. Maybe the children should hold that until they die, or 1031 exchange it if it's real estate or other. But we have to, it depends on, so we all of these scenarios and strategies after the first spouse dies. And you have to pick your poison. What's worse, the capital gains tax, the estate tax, depreciator, or income tax? We have to look at all the tax. Oregon only has a 10% estate tax on small estates. The income tax rates, state and federal, What are we trying to avoid and mitigate? Income tax, estate tax, tax on IRA distributions. So we kind of have to look at all of the assets and all of the taxes and have a tax reduction and mitigation strategy that isn't just related to capital gain. You're talking about capital gains taxes. But the answer to the question, if you own assets, when the second spouse dies, if they're in her, they get another step up in basis.
Sounds like there are a lot of moving pieces when it comes to the individual family, depends on their cases and depending on what are the tax laws at the time. So where are we heading? We're in 2025. I remember you mentioned that some changes are coming in 2026 and our current president has been throwing changes left and right. You never know what you wake up to these days. So where are we heading in state?
So it looks like Oregon is going to try to this bill to raise the small estate exception to allow more assets to avoid probate. It looks like that's going to become the law in Oregon. As soon as that bill gets through the Oregon legislature, if that gets passed, it's interesting. I'm on a listserv that has 10,000 lawyers on it in Oregon. And all the probate lawyers are up. They take all of our, if you raise the exception. And it's like, finally, they're going to raise the exception, but it's always these probate lawyers. Me too. I do probate. But why are we probate and give $50 to $60 billion a year to probate lawyers? That's foolish. Change the law. Like my feeling is if you own a nice home in Lake Oswego, it should avoid probate. Whether it's worth $2 million or $150,000, probate a principal residence. Why do they set the value at $290,000 and say that? Because they know that everybody's houses are worth more than that. And the lawyer's going to get 5% of your house. It's crazy. So, but I shared that the Washington estate tax exemption was just increased from 2 million to 3 million first. So Oregon's exemption is at $1 million. It's the lowest exemption in the country. But once you're over $1 million, Oregon's going to get between 10 and 16% of your estate. I don't think that's going to go away. It's everybody has over $1 million in Oregon. It's pretty rare to have less than that. So if you live in Oregon, your children are probably going to tax after you die. At the federal level, the bill that House would raise the current exemption from 14 million to 15 million and make it continue to index up for inflation. Now the president said, let's eliminate the tax on tips. Let's eliminate the tax on overtime. Let's eliminate Social Security taxes. Let's say that veterans don't have to pay taxes. And then they started looking at the cost of extending his tax cuts and cutting all these other taxes. The bill that came out of the House, they said, will raise the deficit from 37 trillion to 60 trillion in 10 years. It will almost double. And interest rates are 7 or 8%. I mean, it's not fiscally responsible. We asked anybody to raise the estate tax 18 million. The House just did that. And the cost of that is another $600 billion for the wealthiest people in the country. And we all may be in favor of that, but it doesn't like it's an emergency. Another $600 billion of estate tax avoidance to the wealthiest. But that's in the bill that got out of the House and is over in the Senate. I don't think it's going to survive. If I had to guess, if anything, there's that I sent to Yahang before that shows about $117 trillion of wealth is going to transfer to our children and grandchildren in the next 40 years. It's 220 trillion. Do you really government is going to children tax-free? The Secure Act is going after retirement accounts. Always, when we've had a financial crisis, they've always come back to estates and just crushed family wealth. Okay. So if I had to guess, you should be in between 5 and 7 million and probably a 50 estate tax. Trend at the state level is 10 years ago, almost an estate tax, now about 50 do. And I'd say in another 10 years, probably 30 or 40 states will have an estate tax. Wealth transfer. It's literally a tsunami, 217 trillion over 35 years. The government is planning on taking about 60% of that out of your IRAs and income tax and out of all your other assets in estate tax. Right now, we have the lowest taxes we've had since 1919. Your taxes will never be lower. It may not feel that way, but they'll never be lower than they are this year. The problem with the gift tax is the government changes it every year, and we're all going to live another 40 years. So how do you plan for what's going to happen when you die? You have to be very proactive and be on top of it on a year-by-year basis. When things are in your favor, act on it. Don't wait, because it's not going to stay in your favor direction after an election or a midterm. But right now, this year, you have a 14 million exemption at the US level, and that's supposed to go up to 15 million in January and keep going up with inflation. So last year, I think 2,800 families paid US estate tax. It will go down to about 700 people a year out of 4 million that die. Only 700 families will pay estate tax in the United States after this year. Yeah. So they're trying to repeal the estate tax They've done it 4 times since I became a lawyer. Every time it lasted for 1 year, and then they reinstated it. There's too much there for the government to take from our families to actually repeal the death tax. It just is never, it's not realistic to think that they're going to.
It's still a pretty big number for ordinary people. Let's talk about something that is very relevant to many of us, most of us. And since you probably know, Tom, Asian people love real estate. So we love to be landlords. It's very common for people to own investment properties and not mention own a residential home, myself in Illinois. So what are the good solutions to protect real estate from litigation, probates?
So I'll try to be brief with this. It's a big topic. We could do an hour just on this topic, but if you own investment real estate, you need to put it in a limited liability. You should not own it yourself. That's if you own investment property and you're a landlord. Why? First of all, only about 25% of claims by your tenants. Just before I went online, I had a client that just got a $58,000 lawsuit served on them for some mold found in one of their properties. So the reason you put it in an LLC, one can bankrupt you. Your insurance will about claims. The LLC is necessary for the other 75% of claims. And about 85,000 lawsuits get sued every month. Number 2, get $10,000 of state and local tax deductions. Now, that may increase with the new tax law. They're talking about increasing it back up to 40,000 of deductions. As soon as that came over to the Senate, they said, we need to get rid of the state and local tax deduction. So people in Oregon and California pay a lot of taxes. They can't deduct it anymore. If they raise the SALT deduction back up to 40, that's a 10,000. That's why you have an LLC, because you can take tax deductions without any of those limits or constraints. If you own a $2.7 million of investment real estate, let's just say you do, $1,000 a year of depreciations every year for 27 years. Basically what that means is you can take 100 or tax-free for 27 years. Isn't that a good thing? Pay a 0% tax on $100,000 a year. And then last, I don't to take 199A deduction, which is the first 20% of your gross income is tax-free also. And under this new law that they came out up to 23%. So if you make 100,000 in rent, percent of that 23,000 would be paid to you tax-free every year. So tax-free is a good 2 words. So LLCs. And then when you die, everything gets a step up in basis, avoids probate, inherit the LLC, and they can have passive income, which is make money while you sleep. All right. So I just gave you about 7 compelling reasons to set up an LLC if you have investment real estate.
For the real estate, what are the consideration factors between trust and other tools, such as transfer on death deed?
Your residence and vacation home should be in your living trust because they're not investment property, they're personal property. A big mistake people make is they put their residence or their vacation home in an LLC. Never do that. If a lawyer has you do that, in my opinion, it's malpractice. Those are not investment assets. I don't like to use irrevocable trusts because they don't provide the same asset protection. They don't provide the tax deductions. A trust is not a business, so it doesn't get the same outcomes. The LLC is optimal for why are 99.99% of all the business entities that have been formed in the last 31 years in the United States LLCs? They're not LLCs for a reason. 1,500 of them. I have several of my own.
Let's talk about the other of the relevant to everybody. What are the solutions to reduce the capital gains or business sale capital gain taxes?
So it's kind of a combined question. There's 2 questions here. Charitable trusts, or what can you do to mitigate capital gain, I think is the general question. I had a client in Oregon last year, dollars of Tesla stock into a charitable trust. He had like a $100,000 basis and was able to sell it and pay no capital gains tax, state or federal, take the entire 12 million. And then he and his wife are taking 7% income out of that trust for life, which is $840,000 a year for the rest of their life. So they avoided the capital gain. They removed the asset from their estate. They an income asset, 6 years of tax deduction, so that when they do take that 7%, it's at a very low tax rate. When they left in that to a charity that they created, I can set up a foundation, a donor advised fund, whatever they like. With real estate, you can do a 1031 exchange. So you rotate out of the real estate into other real estate, or you can, for example, you can do what's called a Series 22 tenant in common investment, where you the timelines that are required under 1031 exchanges. You put that into a real estate investment trust or a TIC, a tenant in common investment. And basically, you're not the landlord anymore. You don't own the property anymore. You don't have to deal with repairs and landlord tenant or any of that. You just get a $7 check in the mail every month for the rest of your life. And that capital gain is deferred because that's one of the places you can deposit the money for 1031 exchange. And some of my clients, when they've owned investment real estate for 30 years, they get tired. They say, I don't want to be a landlord anymore. I just want to get a check in the mail and let somebody else manage the property. And some people are very good at managing property. They don't charge enough rent. During COVID, you couldn't get people to pay rent, eviction moratoriums, all that stuff. So if you ever get into that type of a situation, you want to get out of the property, let's have a discussion, have your cake and eat it too, right? So that we could do an entire hour just on this topic because women are in this arena for sure.
Yeah, and I also see uprising trend in clients' request to do a irrevocable trust on life insurance. Can you explain to the audience what that is?
So first of all, our host, Yahong, is an world-class expert on life insurance planning, so I will defer to her. I've been insurance licensed for almost 40 years, so I consider myself to be well-informed. My 30-year view, insurance. When I was a young person with 3 little kids and no money, I bought a ton of term life because it's all I could afford. I wanted to protect my family, but I couldn't afford permanent insurance. So I bought millions of dollars worth of term. Now I'm much older and my kids are in college and I'm divorced, and those policies typically term out, and that's good. That means that I didn't die when I was 27, right? Then there's permanent insurance, which is indexed universal life, which can be structured. It's like a super savings account. I call these rich person's Roth IRA accounts. The problem with Roth IRAs is many of us can't put money in them. Tell your children if they're 18 and they're earning income to put money in the Roth from a young age and match the first, I tell my kids the first $2,500, now that you're earning income, that you put in a Roth, I'll match it. So they don't feel like they can't spend their own money. I also match their wages, the first $2,500 a year they earn, because I want them to work. And this is why they're going to college. But my daughter, who's in, the minimum wage in restaurants down there is $3 an hour plus tips. So a full-time restaurant worker in Alabama makes about $16,000 a year. That's discouraging. If you're working really hard, making $15,000 a year. So, but I want my children to work. So I'll match some of their wages. But IUL, I call it a life insurance retirement plan, is permanent insurance. And you can also add a healthcare component to it for a catastrophic illness. You put money in, it just accumulates tax-free forever, income tax-free forever. You typically don't buy this insurance to create a legacy for your children. Usually not. Usually the thought is, I'm going to pack a bunch of money in there. It's going to grow with the market. It's going to have protection under it. I'm not going to put crypto in it, crypto components. And then in my retirement years, like I would with my Roth, I'm going to take the money out of it and pay no tax on the gain or the income. And if I become catastrophically ill, it will pay for my health care. If I never become catastrophically ill, that money that's in my insurance policy will still be there and I can use it for retirement. So that's a win all the way around for you. But when you die benefit, it's included in your estate. The third type of insurance is typically a permanent policy that you pay for before you're 65 or 70. You don't want to have this huge insurance cost hanging over you in your 70s. You want to pay for it. It doesn't have long-term care because it's for your kids and grandkids. And it creates liquidity for your kids so they don't have to sell your house, take everything out of your IRA, liquidate your investment property, and maybe we're in a recession. There's no financial emergency. And I just think it's a good idea to have 3 to 5 million or more of money in a life insurance. When you die, your children get that money, income and estate tax free. And even if you never don't leave them anything else, you know that they're going to get that for sure. And it's the asset that they're going to covet because they can't spend your house. They can't spend they may not want to be a landlord. If they take money out of your IRA, it's going to get hit by Oregon and federal income tax and federal and state estate tax. So if you live in Oregon, you have a 401k or an IRA, it gets quadruple tax. The life insurance and a life insurance trust, 0 of those taxes hit it. It's incredible. People like the Gates family, they buy hundreds of millions of this for their kids at 1 cent. And that's what they leave their kids with. They give all their other assets to charity, estate tax. So you can have a $500 billion estate, pay no estate tax, leave your children once, and they get that completely tax-free. So the purpose of trust in a deferred gift to your kids that they get completely tax-free, that is not going to be in your estate when you die. I call that a family wealth trust. So it's not simple, but I think it's imperative for everybody to consider having.
I'm just reading a question in the question answer. Tom, thank you so much for answering the question on life insurance trust. I'll read this to you. So at age 4, you establish a charitable with $12 million of passive receive $800K year income from the trust. you live to 100 years old, you still get income tax free. I think this is referring to the charitable trust earlier that you mentioned.
So the charitable trust is not as simple. I've done them, but like a husband and wife, if they sold that stock, they 12% to the state of Oregon and 20% to the IRS. So they pay about a 4x. They're still going to do just fine, but net the 8 million, but still it's all in your estate. And you just gave away a third of it in capital gains. I can set up, you have to design the charitable trust. So there's 100% chance. It's called the 10% test. Just doing this to avoid tax, you're going to take all the money out and the charity gets nothing. That's a scam, right? So I have to design to prove to the IRS if there's an audit that the client is really charitable. I design it in my modeling to get the maximum amount out. If they want to give a lot of money to charity, I design it for the client to take the minimum they're required to take and maximize the amount going to charity. I can set up a foundation so that when mom and dad die, the children control the wealth and they can do family legacy planning for causes that the family cares about. But let's say I set it up as a 30-year trust and mom and dad die in year 18. The children would get the remaining 12 years of the 840,000 contributions. Also, annuity trust pays a fixed amount every year. So that would be a charitable annuity trust. A charitable unit trust, you revalue the assets every year on January 1st. And if the value goes up by 10%, the distribution goes. So 840,000 would go up by 10%. That would be 84,000 more. There's inflation adjustment. On the other side, if you're the trustee and you don't invest that 12 million wisely, it could go down by 10%. And now 840,000 is reduced, but called a unit trust because they like to be able to adjustments of living. They put them very conservative investments that grow over 20, 30 years, 5, 6, 7%. So the 12 million drops down maybe to 7 or 8 million. By the time you're about 20 years in, you're getting more like 1.2 million a year. And then when you die, there's 5 or 6 million left over and that goes to the foundation. But if they died before the end of the term, the children would continue to get those distributions. You can change the trustees, the investments, and the charity. Those are the three things, even though it's irrevocable. It's unique in that you can be the trustee. You can't, by the way, own business. And it's not a good vehicle for mortgage property or depreciated real estate. So if you have a $5 million building and you've been taking depreciation on it for the last 15 years and it has a $3 million mortgage, and now that's not a good asset in a charitable trust. There's too many poison pills for that to be suitable for the charitable trust. Another client that died recently had NVIDIA stock. But the husband died. They live here in Washington. They bought the stock for a couple $100,000. It was worth 17 million. But he died up in basis because they live in Washington, capital gains tax free without a charitable trust. So she gave 0.9 million to her 2 children, which is her lifetime gift exemption. Said, here's 13.9 million. She got it capital gains tax free when she sold it. And then she just handed each of them some cash and she kept the other. We're able to do charitable trust needed in that case. So I'm gonna brainstorm with my client and figure out what can we do to help you have a spectacular life, live the way you want to live, stay in your home, thrive, right? Have quality of life, never run out of money. If you have abundance in your life, let's figure out and let's give the rest of it to people you love. If you have 12 million and it's going to grow to 18 million and you're a widow, do you need to keep all that in your estate or giving some of it away, right? And what if you love Dornbecker Children's Hospital or your church? Let's try to help people while we're living. And why do our kids have to wait till they're 6 a gift? Maybe we can help in a house or something. So this is really exciting and fun to do. This isn't about death. This is about life.
When you explain these specific details, I really feel it takes the wealth of knowledge and experience to be able to custom design for each family. There's no cookie cutter answer here. And we are running out of time.
Yeah.
I just want to reassure people that I see like specific questions coming in. I would encourage you to sit down with Tom to have a private conversation about your family specific needs. And Tom is just any questions you see, I throw at him answers or provoking thoughts to make you think further in that question, right?
Yeah, and Johan email and stuff, and she'll be sending some handouts to you. But if you want to send those questions to me, I'll answer them in writing and handouts at no charge. Yeah. I don't charge for consultations. We can meet on Zoom. If necessary, we can meet in person. I'm in Portland quite a bit. Our main office is in Bellevue, but what I've been doing in Oregon is just delivering the estate plans right to your home. So you don't even have to click if you don't want to, but I'm happy to answer your question if it's very specific and send you information because I want you to be empowered with knowledge. And I will usually get back to you within an hour or two of getting your question. So, whether you decide to act on that or not is completely up to you. I'm hoping you will, and that I'll make you an estate planning expert on all these topics, and then you can share your knowledge with people you love, like your parents, your own parents. You can probably help with their planning. It depends on where you are in that stage of life, or your business, or whatever it is. But this can be a lot of fun. It often involves less than 5 hours of your time to everything structured properly. It might be the best 5-hour investment you ever make in your life. You'll have a lot of peace of mind.
Tom, a client of yours, who's also a client of mine, it's such a calculated the number of days he spends in US. I'm not going to mention name, but you probably remember them. They don't have to pay any tax. He doesn't have to pay any tax in the US. He just got a stage 3 cancer this year.
Oh no.
I think he's going to have surgery the day after tomorrow. So,
by the way, this administration, who's running our country, they're going to go after, if you're not a US citizen, they're coming after pretty much everything. All the protection you have if you're a student or you're a green card holder. They're talking about getting rid of the green card and have a card with the president's face, picture on it. Pay $5 million to have the green card. Revoking the H program. I mean, it's scary times. So it's lock things down and be protected sooner than later. I don't know what's going to happen because there's almost 4 years till the next election. It's kind of scary times though.
I do have a former friend that some Intel family received notice from ICE to be out of the country within 25 days. It's really happening. So I shared the story about my client who is so good at current US laws to be not in country for more than 3 years, but you don't know what happens in life next second, and you certainly can't control the law changes, right? So we need to rely on experts like Tom to make your family plan proactively, not reactively. Your time spent with us, and we will share the handout you give to me with our audience. And yes, we can also share the recording of this workshop as well.
And I'm honored. Everybody attending the event is smarter than me and successful people and wonderful people. I'm just honored to have the opportunity to share what I know, and I'm very passionate about it. I hope to meet many of you. Yahong and I were talking about maybe doing an event this summer in person. I'm fine in either setting, but I'll be around a lot during the summer because it's a more relaxed and informal time than the winter. So I hope to meet many of you, but thank you for inviting me, and I look forward to doing this again soon.
All right. Thank you so much, Tom.
See you later.
Thank you, Tom.
Bye. Take care.
Bye. Bye.